subtitle is Thailand's Deep State, Royal Power and the Constitutional Court, because I actually use my study of the Constitutional Court as evidence of the existence of what I call the deep state. So I'm going to start. This is my outline. So it looks very very dense. I will try to make that as simple as possible, but it's yeah, I'm really trying to look at how, first of all, how the Constitutional Court was introduced to Thailand, how its role evolved in history, in recent history, and then how we might conceptualize the Constitutional Court in the future as a substitute king. Sorry for the here, the substitute king. Yes. No. Here and then it's very much at the end that I will explain about the deep state, right? So you have to, I'll have to keep you waiting so that you don't fall asleep in between. Right, so there are, I identified roughly 4 phases in the history of the Constitutional Court. So first of all, it was introduced in 1997 as part of the 1997 Constitution. And at that time, I argued that the Constitutional Court was thought of as an insurance mechanism. So I use a theory by Tom Ginsburg, who writes extensively about the fact that the Constitutional Court is usually imported and used in constitutions because it ensures constitution makers an insurance against the future. So if constitution makers are in the future part of the opposition, then they will have this Constitutional Court as an insurance mechanism to safeguard their interests, right? Phase 2 and 3, I use, so I identify this as judicial empowerment, which happens in 2006, and then judicialization of politics unfolds from 2006 onwards until the military coup in 2014. So here I use a theory by Ran Herschel, who wrote about Constitutional Court as hegemonic preservation tools. So it's the idea that whenever democratization is under process, threatened elites will choose the Constitutional Court to safeguard their interests. So actually it's a little bit, it's one step further from Tom Ginsburg theory, right? So it's not only an insurance against alternation to power, but it's a way to insulate preferences in a definitive way from the rise of democratization. Okay, everything is going to become clearer as I speak. And then the 4th phase, which is starting now and has been, there were several attempts to make this phase start before now, is to transfer the powers of the Constitutional Court, of the king, sorry, onto the Constitutional Court. So to create a Constitutional Court as a substitute king in the post-Bhumipol era. So after succession, we will need to have some form of moral authority, and this will be the Constitutional Court. All right, so first of all, you're all familiar with the vicious cycles of Thai politics. So basically coup d'etat, interim constitution that gives all powers to the military leaders. Then in the interim constitution you have the promise or the mechanism that is set for the drafting of a permanent constitution that will allow elections to happen. Then the permanent constitution is promulgated, you have elections and then a crisis and then a coup d'etat. Right? So the 2006 and the 2014 military coup d'etat were actually similar to previous sequences in which you had a coup, an interim constitution, a permanent constitution, elections, crisis, and back to a coup. But what is different in 2006 and 2014, and that's how the deep state concept is going to be useful, is because we have in between the elections and the military coup d'etat, we have the use of the constitutional courts in what some might call judicial coup d'etat. So here, this is the use of the courts. The Constitutional Court, first of all, but also other courts. Once again, I think you're familiar with the sequence of how the military coup d'etat happened in 2006 and 2014. But I'm showing you this, this table so that you can see clearly how the courts have played a major role in paving the way for the military coup. So in both cases, we had an election, then we have street protests against the elected leader, then the elected leader dissolved the house, snap elections are organized, boycotted by the opposition. Based on this boycott of the elections are ruled unconstitutional by the Constitutional Court. Then it's after that we have a few differences in 2006 and 2014. In 2006, after the Constitutional Court ruled the election unconstitutional, what happened is that some election commissioners who were seen as favorable to Thaksin were sent to jail. So here we have the role of the criminal court, not only the Constitutional Court, but also the criminal court, in helping to pave the way for the military coup, because those election commissioners, they wanted to rerun the elections in constituencies in which there were problems. So we would have maybe managed to exit the deadlock if those election commissioners had not been sent to jail by decision of the criminal court. In May 2014, it's a little bit different. It's not the criminal court, but the Supreme Administrative Court that kind of helped pave the way for the military coup as complementary to the role of the Constitutional Court. So what happened? In May 2014, the Prime Minister Yingluck transferred one civil servant, Tawil Pliansi, from one post to another position. The Supreme Administrative Court ruled that this was illegal because the motivation or the reason for the transfer in the Administrative Act were not sufficiently made, so it was not the right reason that was stated from moving this civil servant from one position to another position. So based on that, then the oh, sorry, I didn't put it here, so it's in between March and May. And that's based on that the Constitutional Court afterwards dismissed Yingluck, saying that she had done something illegal, as the Supreme Administrative Court said. Therefore, it was incompatible with her function as a Prime Minister, so she had to be dismissed. Right, so here you have the Supreme Administrative Court. And then we go back to having the same sequence: military coup d'etat, temporary constitution, and permanent constitution. Except, of course, in the case of 2016, or in the case of 2014, the time between the temporary constitution and the permanent constitution is 2 years, as opposed to not even a year in 2006. And even though we don't know if we're going to have a constitution, because maybe there will be no referendum if the Constitutional Court says that the referendum law violates the constitution. So this is unclear. Anyway, you see we have the same sequencing, and we have a very important role of the Constitutional Court in paving the way for the coup, sometimes with help from Criminal Court or Supreme Administrative Court. Right, so this is what I'm gonna, of course, you know their faces. So I didn't know exactly who would be in this room, so I think I don't need that. Okay. So here you see we have these same sequences. So the question is how come do we have a Constitutional Court that really seems to work against democratization in annulling elections and paving the way for military coup d'etat. So let's look a little bit at the history of the Constitutional Court. The Constitutional Court of Thailand is prima facie something that is very liberal, very independent. Actually, it's copied from the German model. So what happened is that in 1995, in Thailand, they studied ways to have a constitutional court looking at foreign models. So they commissioned the Democracy Development Committee that was chaired by Prawet Wasi, commissioned studies on foreign models. And here, the one on the Constitutional Court, they studied, for instance, Germany, Austria, France. But they didn't go for the French model. You know the French model, the French Constitutional Council is not very powerful, as opposed to the German Constitutional Court. So they really went for a German Constitutional Court that was to be powerful and very independent. So how is it independent? When we look at Constitutional Court and we want to assess them, we look at how independent their selection is. Are they dependent on the political party and the elected government or not? So here you have a map of, or a chart of how the Constitutional Court judges are selected. So this is, I'm sorry, this is from 2007, not 1997, but actually 97 and 2007 are the same, except that you have more, you have 15 in 1997, 15 members of the Constitutional Court, and you have 9 in 2007. So it's not the same numbers, but it's the same. You have more than half of the numbers that are selected by the Supreme Court and the Supreme Administrative Court. So no interference of the elected government or any government. It's really internal selection from the judiciary. And then for the other one, you have a selection committee. So in 1997, as part of the selection committee, you had some political party representatives. So you had a small number of people representing the political branch, but then the other people were university deans of universities. And then they select only less than half of the members of the Constitutional Court. So here, if you're a comparative constitutional scholar, you're like, okay, the Constitutional Court of Thailand is really independent. Right. Okay, so then moving on. Is it an insurance? Okay, so who drafted this constitution in 1997, and who were the main advocates for the import of the Constitutional Court? So here I identified someone I'm sure you know, who is Thammasat University. So he was the one, if you look at the constitution drafting minutes, you will see that talking about the Constitutional Court, 90% of the time he's speaking. So he's the one speaking all the time on the Constitutional Court, saying what has to be said, and people kind of just accept what he says. So he completely dominated the process of importing the Constitutional Court in the 1997 constitution drafting process. Right. So how is that an insurance? Well, it is an insurance because in 1997, it was the beginning of democratization. So no one had a clue what would happen after 1997, what kind of democracy we would have, what kind of leaders would be elected, what kind of political parties would be formed. So having a constitutional court is a way to mitigate the risk associated with emerging democratization. Let's say there is a fascist party coming on, then the Constitutional Court will be able to rise against that party, to dissolve the political party, right? So this is an insurance. Also, there are personal interests at stake. So I use John Elster theory of constitution making. John Elster, talking about constitution making, identify 3 types of interest. What he said is that basically constitution making is about the interest of the constitution makers. So interest of the constitution, of the personal interest of each individual constitution maker, group interest of the group that drafts the constitution, and institutional interest of the institution that drafts the constitution. So here the personal and group interest. The personal interest is maybe to have a role in the future in this constitutional court. The group interest would be to give a stronger role to legal jurists, legal experts or jurists in the Thailand of the end of the 20th century. And then institutional interests here are quite hard to find, so this would not work. But individual and group interests are represented here in the person of Thammasat University. So here we really have this idea of insurance in uncertainty as to what is coming next. Next, what happened? 2006, we have the military coup. 2007, we have the permanent constitution. And this constitution then, under this constitution, you see a flowering or a flourishing of constitutional court cases that go way beyond what had been envisioned in 1997 when the constitutional court was imported. So that's why I use this cartoon here. You see it's written here, Tulak and Piwat, Kham Khun, so within overnight, then the judiciary here, with the night all here, the judiciary just completely destroyed the parliament and the government, right? So this is really the idea of what happened, the feeling of what happened in Thailand from 2008 roughly, under the 2007 constitution, until the military coup of 2014. So I think, actually, I'm not sure what Dr. Piyabutr is going to talk about, so I don't know if you're going to talk about the several cases that happened during that time. So I will not go into details. I will just look at one decision, which was the most emblematic of all the decisions that were taken at that time. It is the decision to prohibit constitutional revision in 2013. So what happened is that, you know, the government of Yingluck wanted to revise the constitution. It was part of the electoral program in 2011. Then they were elected, and they went on and tried to revise the constitution to have a fully elected Senate instead of a half-appointed Senate by a selection committee of 7 people, right? So under the 2007 constitution, 7 people appointed half the Senate. And those 7 people were members of the constitutional, the president of the Constitutional Court and president of independent organizations. So here, the Constitutional Court said in 2012 first, and then in 2013, in 2 decisions, that the proposed constitutional revision is dangerous. It will create disharmony in Thailand. So if we have a fully elected Senate, we will have big problems in Thailand. And so this is unconstitutional, and so the constitutional revision cannot happen. Right, so this is something that is unprecedented. Why? So this should be the constitutional scholar telling you this. It's because, of course, when the Constitutional Court undergoes a process of judicialization, which is defined as when the Constitutional Court goes into the political arena, so oversteps its powers and go into the political arena, then the remedy to still have democracy is to be able to revise the constitution. Right? So in the end, it goes down to the people. They can revise the constitution and go against the Constitutional Court if they wish so. But here you see the constitutional revision was forbidden by the Constitutional Court. So this is the highest thing, or the most, the thing that a constitutional can do, which is exhibiting the highest power. And that's why when this happened, it was labeled a judicial coup by the Thai public. Not everyone, but at least a portion of the Thai public. So at that time, I saved this poster that I found on Facebook. I don't know who shared this, but as you can see, it's 2006. You see on the left here this old TV and the military coup leaders of 2006, and here you have 2012 here and the 9 Constitutional Court judges, and it says, well, here you have a flat screen, where in 2012 here you have an old TV, and they don't have the same uniform. It's not the same. But actually, it's in the end, it goes down to the same. It's still a coup, right? So this would be more sophisticated than this. That would be maybe more archaic or more from the past. Okay, so how can we see that this process of judicialization of politics with many constitutional court decisions are a self-interested hegemonic preservation? So here I'm borrowing from Ran Herschel. He said, okay, judicialization of politics as a self-interested hegemonic preservation is when the judiciary, so the Constitutional Court usually, goes into those domains here, which are supposed to be political arenas. So electoral processes, the executive and the legislative powers, collective identity, regime legitimacy, and social conflict. So if we look at the Constitutional Court cases, sorry, I didn't go into details because I don't know how much you know, if you've experienced those events yourself, so I didn't go into details. But we have all those arenas that were invested by the Constitutional Court, and we can just take a few decisions of the Constitutional Court. First of all, electoral processes. We have nullification of elections in 2006-2014. That's what I said at the beginning. We have party dissolution, so 2007 and 2008. 2007 it was Thairak Thai. 2008 it was Thairak Thai as well, but which was reformed and called Palang Prachashon at the time. And so this party dissolution here paved the way for the rise of power of Abisit Wujatiwa, which is who is the representative of the opposition. So here it was also labeled a judicial coup, because by dissolving the ruling party, it just removed the prime minister, who was also banned from politics, and all the ones from the party who were part of the executive board, they had to also be dismissed. And so change of majority in the lower house, and then we have the opposition coming to power for 2 years without having been elected, right? So this was also constitutionalized in the 2007 constitution. If we look at regime legitimacy, regime change, we have many decisions in 2007 with regards to the legitimacy of the 2006 coup. Actually, I didn't update this, but we have decisions in 2015 and 2016 with regards to the legitimacy of the 2014 coup. And then we also have this intervention to prevent revision of the constitution, which is clearly a way to prevent what they see, what the Constitutional Court sees as a regime change. And finally, we have this as well. Many cases, maybe you ask me questions if you have questions about that. The Samax case, you know about it?
Cooking.
The cooking show. Okay, yes, so I removed that, but yes, exactly. So Samak was a prime minister, and then he was famous for hosting a cooking show. He went on his cooking show, and the Constitutional Court ruled that this was incompatible with being a prime minister because he had no right to be employed by any firm. And so being on this cooking show was being an employee of this firm, and so he was dismissed, and that's how he lost the job of prime minister. Right. Okay, and this leads me to self-interested hegemonic preservation. So why do we do judicialization? It's when we do that as constitution makers, as members of the judiciary, when democratization process threaten the old elites, right? So this is, I take this from Ron Herschel, say, okay, when the interests of the old elites are challenged in majoritarian decision making, then they need to resort to the courts. And this is not something that is special to Thailand. This is something that happens also elsewhere, especially here. I put this book, which is, I think, a PhD thesis on Constitutional Court, their role as hegemonic preservation. Sorry, can you, it just, has it been off for long?
Oh no, just
Okay, because I'm just thinking on there, nothing. Okay, so yeah, this is a book cover. A Turkish student who wrote about hegemonic preservation of constitutional court in Turkey. All right, and so Ron Herschel identified 4 conditions that lead to judicialization of politics as a self-interested hegemonic preservation. So here I just want you to kind of see how this is not peculiar to Thailand. I know that as scholars interested in Thai politics and in Thailand, in Thai studies, we always try to find ways to explain Thai politics as based on its exceptional character. I would like to say no, there is no exceptional character of Thai politics. This is something that happens in many countries in which traditional elites want to delay democratization. So here are the 4 factors. First of all, election outcomes do not represent the elite's interest. Second, election outcomes bring about possibilities of regime change. Third, we have a crisis, and then we have powerful actors that empower the courts. So all those conditions are here. First of all, the election outcomes from 2001 to 2014, the same political party has always been elected in Thailand, right, which is Thaksin's party. So they do not represent the interest of the elite. We could talk about this for hours and hours, so I'm not going to go into the debate right now, but for sure, they threatened somehow the old order. Okay, so they did not represent the traditional elite's interest. Then
you call the book cover that you talk about.
This is here.
I see. Okay.
Yes.
Okay.
You can, I think, download it for free on some pirate website. Anyway, then the election outcomes, they bring about, they challenge state ideology. So this is also something we can debate, but I would argue that they do, because Pheu is somehow challenging state ideology, especially with the 30 baht healthcare scheme, because it like reverses the system, which used to be based on charity, the king's charity, fountain of charity, to social justice. And when there is social justice, of course, healthcare is no longer a charity, it's a right? And everyone has the right to ask for it without having to beg. Right? So this is a challenge to state ideology that is quite clear. Then we have the political deadlock that allowed the court to step in 2006. And then powerful political actors who empowered the courts. So this is the king in that case, because in 2006, when just after the election was just after the election was held, before it was nullified, and it was like a big vacuum, what's happening now, he held separate audiences to the Supreme Administrative Court judges and to the Supreme Court judges, right? So in two separate speeches to them that he just conveyed for the occasion, he said, well, you have to act. You have to act in my name. If you don't act for democracy, you dishonor my name. And after that, there was a press conference, and a few days later, the Constitutional Court ruled that the election was unconstitutional. So here it's like Thailand is a textbook application of Rand Herschel theory from A to Z. Right. So I've spoken for about 20 minutes now, so I'm going to my third point, which is that in the future, the Constitutional Court is at least envisioned as a substitute king for the future, so in the post-political era after succession takes place. So I just take two informal traditional roles of the king. The first one is to solve crisis, and the second one is to give some validity to changes of government, to new constitution, to coup d'etat through royal signature. Right? So this could be identified as two roles of the constitution of the king. And we'll see that the Constitutional Court is taking on those roles. First of all, you've seen with everything I've said so far that already you can see a sketch of how the Constitutional Court is acting to solve crisis.
And the chairs, the same chair.
And yeah, there's also a symbolic of it. So I will be very quickly. Crisis powers. Okay, crisis powers. You remember in 2006 when there was this crisis in Thailand, the royalists, they called for royal intervention, and they said the king has to appoint a prime minister of his own liking, and they quoted Article 7 of the 1997 Constitution, which states, whenever no provision under this Constitution is applicable to any case, it shall be decided in accordance with the constitutional practice in the democratic regime of government with the king as head of state. So they quoted this. The king said, no, this is not possible. But the point is, why did they quote this? It's because they tried to use this constitutional practice, so the idea of a constitutional convention, to apply to invoke the king's role to appoint a prime minister based on precedents in 1973, 76, and 1992. So they did that, and it didn't work. But actually, Article 7 was first envisioned as giving this power, so the power to interpret the constitutional practice in the democratic regime of government with the king as head of state, to the Constitutional Court and not to the king. So this is very interesting. First of all, you see that at first, this Article 7 was Article 264 in the first draft, right? And this was how it was at the time in June 1997. So at that time, Article 264 said that exactly the same, but that this is the power of the Constitutional Court to interpret and to apply constitutional practice in the democratic regime with the king as head of state. And then what happened? There was a very long debate, very interesting, that you can read if you read the minutes of the constitution drafting process. Finally, they said, oh my God, it gives too much power to the Constitutional Court. We have to remove any mention of the Constitutional Court and move that article somewhere else. And and so they moved it to Article 7. Then, after that, so I'm talking about the power to solve crisis by appointing a new prime minister. In 2007, we have yet another attempt to give this power to the king, not to the king, to the Constitutional Court. And this was the fourth paragraph of Article 68 at the time. And so I put it here in Thai as well. So it gave power to the Constitutional Court to solve crisis, right? To solve crisis in case there is a crisis, and to have like a meeting, to call for a meeting of the president of the courts, the president of the Senate, of the lower house, and the opposition, to find ways to solve the problem. And actually, at first, this article here, this is also one document from the constitution drafting process in 2007. This article was envisioned to actually give power to the Constitutional Court to nominate a new prime minister. In case the prime minister is removed, let's say by the Constitutional Court, then we would have the Constitutional Court involved in, so the president of the Constitutional Court and also of other courts, the Supreme Court and the Supreme Administrative Court, the power to choose a new interim government. So here it's very clear. But then it was removed because it was too clear, right? And so it was removed, and then this paragraph, it became this paragraph, and this paragraph was also removed because in Thailand it created a big uproar, and so there were many debates and civil society groups, and also many noted scholars called for the end of this paragraph. So in the end it didn't happen. But now, in 2015, it came back. So in 2015, we have it back. So in the draft, in the April 2015 draft, we can see that we have those discarded articles all merged together in the Article 7. Okay, so we have first of all the Article 7, and then it gives power to the Constitutional Court to make the decision. Right? Okay, April 2015 is a long time ago already. So here I put the March 2016, which is the same. I didn't have time to translate it. So just for those who can read Thai, so it's Article 5, and you have same, once again, this is the President of the Constitutional Court that in case of crisis is going to call for a meeting of the President of the different courts and so on and so forth to find a solution. Right? So we have this here. These crisis powers that are the traditional powers of the king have been transferred onto the Constitutional Court. Although if we look at all the drafts, we can see that the military also wants to have crisis powers. So we have this fight between the military and the judiciary on who's going to have the more crisis powers. So first, usually in the first draft, Bangkok gave the Constitutional Court power to solve crisis, and then the military, at least that's how I interpret it, the military said, come on, we need more crisis powers as well. So then we have the second draft that gives more power, crisis power to the military, but then Thai people are not happy with it, so then it's just dropped, or it's too, once again, too chachen, so it's dropped. And then in January, you have another draft by Michai that gives much power to the Constitutional Court, so I don't have time to really go into details. And then the second draft is giving power to the Constitutional Court, but also to the military to have to solve crises. And I will conclude with regime change and validity of coup constitution by looking at just the revision process in the April 2015 constitution. Well, actually, since the first draft, April, until the current draft, constitutional revision is completely impossible. It's impossible. And so what does it mean? It means that the regime is trying to prevent any sort of attack by the elected government against the constitution. So this is also relates to some form of traditional power of the king to say what is accepted or not in terms of changing regime, right? Because here basically the constitution is saying that the constitutional court is going to say what constitutional revision is possible or not. So in April 2015 it had to go, it could be invalidated by the constitutional court. In the current draft also the constitutional court can has a very important role in constitutional revision, but I don't want to touch on that because maybe Atana Piyabutr is going to talk about it. And so, finally, we can see that there is this attempt to transfer the king's role onto the court, and this was initiated by the king himself, who told the court to do that. So I think I've spoken way too long, so I'm not going to talk about the deep state, but I'm just going to conclude by saying that the deep state, this is the legal elites, so the judiciary and the military that are in an alliance with one another and anticipate. And how do they maintain their power? It's by relying on the barami of the king. And so if the barami of the next king is not strong enough, they will have to find ways to find new ways of legitimacy. And so that's why they need to have a constitution that is really institutionalizing their power a lot more than in the past. I will just put it. So I have a lot to say. So we have the legal elites, we have the military, and they're trying to preserve the deep state. Thank you very much.
Hello everyone. First of all, I would like to thank Nitirat inviting me in this conference for this conference. And before starting my presentation, I must apologize as my English is not as good as it should be. So I am not used to presenting in English. So I will read a text I have prepared. So my subject is Tulakan Piwat method and its effect. Since the 25 April 2006 royal speech, which led to an increased involvement of the judiciary in the political crisis, the word Tulakan Piwat, crafted by Thirayut Bunmi, has been used extensively in Thai politics. Many court decisions play a critical role in the crisis. In this article, conference, I will try to conceptualize the word Tulakan Piwat through an analysis of political court ruling since the royal speech on 25 April 2006. First of all, I define the word Tulakan Piwat. For me, maybe I think different with Eugénie. I think the word judicialization of politics is maybe it sound a good word. But the word Tulakan Piwat for me, I think is the bad word, is the worst word, is the political instrument. So I define Tulakan Piwat as a process whereby court play a political role by deciding on case which target political group considered as threatening to the traditional elite regime. So it's different. Tulakan Piwat is a weapon against politicians. Tulakan Piwat is a process whereby court play a political role by deciding on case whose objective is to harm political group considered as threatening to the traditional elite. So for three stages of Tulakan Piwat, first stage, it starts on the royal speech on 25 April 2006 to the adoption of the 2007 constitution. And second stage, forms Somchai government and the change of government to Apisit. And third stage, English government to the 22 May 2014 coup. The three parts of Tulakan Piwat in 2006 to 2007 and 2007 and 2012 to target only one political group, namely the Thai Rak Thai Party, Palang Prachachon Party, Pheu Thai Party. The three parts end with the overthrow of the government. So method of the Tulakan Piwat. The first one is through interpretation, and the second one is through the use of political and moral argumentation in ruling. For the first, the creative interpretation of wording in the Constitution. We can find many words in Constitution. For example, Nitirat, Jariyatham, Kunatham, and the court interpret of wording. There are many ambiguous words in the text of the Constitution, Nitirat, Kunatham, Jariyatham, and the court used this word to interpret extensively in an arbitrary manner. For example, the court has referred the word Nitirat in Article 3 of the Constitution to support its intervention in the field of control of constitutional revision, even though it has no power. And second, the use of political and moral argumentation in ruling. On May 2007, on the ruling on the dissolution of the Thai Rak Thai Party. In the May 2007, the court used the opportunity of the ruling to criticize the election, the politician and the Thai Rak Thai Party. They have said that the politicians are a threat to security. And November 2013, on the election of the Senate. In the ruling on the change to an elected Senate, the court clearly made a reference to the danger of parliamentary dictatorship. It is not a legal argument at all. Constitutional revision would make the country go backward, restore some weakness of the Constitution 1997, which would be dangerous to be the unity and the face of Thai people. The Senate would be a house of wife and husband. It would no longer be a wisdom house. So next one, I would like to talk about a condition of Tulakan Piwat. Tulakan Piwat cannot work alone. There must be other actor and process involved. First of all, is loyal spirit. Before the 25 April 2006 speech, the court was exerting judicial restraint, especially in political case. It was passive. The royal intervention has changed the paradigm for the Thai court. The Thai people believe that every conflict must be solved by the court, it last resource. And second, it must have a painful Democrat party opposition, a non-elected senator, independent organization. The court cannot take up a case by itself. There must be a case filed by a plaintiff. There must be a pool of active plaintiffs who file many cases on the same issue from which the court can choose. For instance, the Democrat Party, the non-elected senator, and independent organization. And the court opened the door with joy to these people. And the third, the retroactive legitimization of court action in Constitution. After the royal speech, the court have expanded their power without clear legal basis. Later, a legal basis for this intervention were written in Constitution. For example, the text about the party dissolution. The fact that the violation of electoral law by one member of the executive board of the party leads to party dissolution and suspension and ineligibility of the entire executive board was first created by the court decision in 2007 and later constitutionalization on the Constitution 2007. Other example for the Articles 68. The Attorney General must screen the complaint first according to the Constitution, but the Constitutional Court said the opposite in 2012. Now, the new draft constitution suppressed the step of Attorney General in the process. And the last discourse on independence and impartiality of the court. I think many people in Thailand believe that the court are independent. They are indeed, I think, they are indeed independent from the government, but not from the traditional elite, from the monarchy. So, Tulakan Piwat born after the royal speech on 25 April 2006 become a discourse in Thailand. Some issue cannot go to court. In some matter, the court have no power to exercise their control. But Thai society always yearn to the court because Thai people feel that it must be the last resort, last arbiter of dispute. In reality, according to legal principle and to the theory of the separation of powers, there are some issues that should not be resolved by the court. There are some issues which are meant to be dealt with through the democratic process. But when the discourse Tulakan Piwat was built, it became generally accepted that all disputes had to be resolved in court. Tulakan Piwat is a process whereby court play a political role by deciding on case whose objective is to harm political group considered as threatening to the traditional elite regime. Tulakan Piwat rests on the legitimacy of liberal democracy, according to which there must be a control of elected institutions. Tulakan Piwat is the opposite. It seeks to sanction elected institutions which represent a threat to the system. The exercise of Tulakan Piwat took several forms. A direct sanction of elected politicians, for example, the case of political party dissolution, dismissal, seizure. The second, the protection of its own power, protecting self-competence. For example, the case on the blocking of constitutional revision. The third, attack against the legitimacy of the government to pave the way for other intervention of the non-elected branch. And the building of the political vacuum, for example, annulment of election in 2006 and 2014. So I talk about why the Thai jurist is the conservative royalist jurist. So the international dominant ideology for today is liberal democracy. When we refer to democracy, we actually mean liberal democracy, which is made of two components. First, democracy, whereby sovereign power resides in the people. Therefore, all state institutions must be accountable to the people. And liberalism, or the rule of law, whereby the power is limited by law. The Constitution guarantees rights and liberty and the separation of power. And there are institutions of checks and balance, such as the court or independent organization. Thailand could not remain insulated from the general trend rule of law democracy. So the question became how to put the royalists into rule of law democracy discourse. So the rise of rule of law in Thailand means the rise of jurists, and the rise of jurists means the rise of royalist jurists in Thailand. First, the role of doctrine, the law of legal academics. Doctrine had two important roles for Thailand. First, put emphasis on the monarchy at the center of constitutional law. And second, build discourse on political reform. Legal academic make the monarchy the keystone of constitutional law and build a discourse on political reform. I will talk about the first, the creation on the monarchy as the center of constitutional law. When liberal democratic ideas spread to Thailand, the kingdom engaged in a democratization process. Thai royalists could not escape democratization, yet they managed to end the spirit of royalists in liberal democracy. From 1990 onward, constitutional jurists to build royalist liberal democracy by placing the monarchy at the center of constitutional law teaching. Constitutional law was made to acknowledge royal power, even though by nature are intended to limit royal power. Likewise, no credit was given to the Revolution Day, 24 June 1932, nor to the first constitution on 27 June 1932. And the royalist jurists tend to construct a royalist constitutional history. Several academics in the field of law play a role in building knowledge in the legal discipline about the monarchy. However, the most interesting case in the case of Professor Bawonsat Uwanno, because unlike the author who merely described the goodness of the monarchy by referring to royal speech, but Bawonsat really attempt to build a legal theory of the monarchy. Professor Bawonsat has proposed many theories. Firstly, the monarchy is the center of the nation. He said, in constitutional law, we teach according to foreign principle that a head of state, being a monarch, cannot do anything except when the government forward a text to the monarch for his endorsement. According to the British, the king can do no wrong. What makes the British monarchy a mere symbol of the nation? In Thailand, the monarchy is not only a symbol, but also the center of the nation, which play a social role as crisis solver. Therefore, royal power as enshrined in the law is different from the British, because the Thai monarchy is a lot more than the British monarchy. He said that also if there is such thing as a nation state, it's because people in society have a shared image in common, past and a will to continue in the present and the future. If such a feeling is missing, the state cannot survive, it will dislocate. And the Thai monarchy is the institution that binds together the Thai nation. The Thai monarchy is the source of the Thai nation from its ancient origin until today. The Thai monarchy is the sole institution that embodies the continuity of the Thai state. And besides this, secondly, Bawonsat also built a theory, sovereignty belongs to the monarchy and the people. In the Thai system of democracy, sovereignty resides in the monarchy and the people. It differs from other countries in which the people are the sole bearer of sovereignty. There are two reasons for this. First, the Thai monarchy has been one which the people, and this has become tradition. Second, relate to law. From time immemorial, sovereignty belonged to the monarchy. When the Khana Rasadoran changed the system of government, the monarchy who had sovereignty bestowed it onto the people by giving them the constitution and accepted to be under the constitution, but still had this power on behalf of the people. That is why whenever there is a coup d'etat that abolishes the constitution, we should consider that the power that was given with the constitution come back to the monarchy. The sovereign before 24 June 1932 in international law, foreign government should not recognize the new government because this is an internal matter and the monarchy is the owner of sovereignty. he said, the People Party Khana Rasadon never had legislative power to issue law in the form of a decree or executive order. Thus, the change of regime in 1932 was a revolution in political sense, but not in the legal sense, as there was continuity between the system of absolute monarchy and the constitutional system through the monarchy. Second, the role of a legal academic in building the discourse on political reform to be used by jurists and technocrats. The movement for political reform emerged after the May 1992 event. Among the jurists who play an important role in building the discourse on reforming politics through the constitution drafting process was Professor Amon Jantarasomboon. He was former Secretary General of the Council of State, and he had influence on the jurist, technician, and a group of public law professors in university. Amon was the one who set the trend of public law in Thailand. Many university professors choose to study public law in France and Germany. It constitutes a notable shift from the past where jurists educated in Anglo-Saxon country had continuously dominated the field. Amon wrote in 1994, Constitutionalism, the Solution for Thailand. This work was very influential in the university and the Council of State, even though there is no theory at all in it. Amon imported the word constitutionalism, which was developed in the West, to explain with his own formulation that constitution, according to the concept of constitutionalism, is a way of writing constitution to design political institution and administrative mechanism in a way that would mitigate the negative effect that could arise from improper behavior of interest seeking by politicians and interest groups. Amon's thought is as follows: whenever it is impossible to refuse the holding of election, it is impossible to deny right to politicians. It is recommended to design a constitution whereby independent organization would check on politicians. Amon considered that having a constitution according to the own concept of constitutionalism is a genuine measure of reforming politics. And the word reforming politics does not mean revising the constitution only, but also revising the constitution and law to address weakness of political institutions in the parliamentary system. Amon believed that drafting a constitution in line with the principle of constitutionalism consists of three components: national political leader, quality academic, and people ready to understand problem to vote in a referendum to adopt the constitution. According to Amon, the most important condition were there should be national leader. If there is none, then a constitution cannot be born, as the leader should be the one launching the whole process. With regard to law academic, they were to be involved as a technician in charge of drafting the constitution. And finally, people were to vote in a referendum. Amon's book prompted jurists to become technocrats. Before that, Thailand had technocrats in the field of economics. But as of now, technocrats must be jurists and help design political institutions, draft constitution, and become member of independent organization of check and balance. They have themselves designed. The 1997 Constitution and the 2007 Constitution have created many institutions of check and balance. Those institutions claim they draw legitimacy from their mission of check and balance. Starting with the 2000 crisis, it became clear that these institutions were a political force that could gain power in the name of check and balance. Another part, I talk about the role of court. The 1932 revolution in Thailand did not affect much to the structure of the court. Even though Thailand had new political institutions such as the parliament, the government, in the case of court, one can say there was a legacy from the old system. First of all, this continuity stems from the fact that the court were reformed during the time of absolute monarchy to escape colonization. Reform that the Khana Rasadon continued in order to get rid of extraterritorial treaty in line with one of the 6 principles proclaimed by the Khana Rasadon, independence. The Khana Rasadon reformed the structure and the procedure of the court to make it look modern, but did not attempt to change the mindset of judge, mentality of judge in accordance with the new regime. In the conscience of judge, the court is an institution that is ascribed to an old tradition crafted continuously starting during the time of absolute monarchy. It is not a new institution resulting from the 1932 revolution. Pridi Phanomyong created Thammasat University in 1934 to produce citizens of new regime. But regarding producing judge, no particular effort was made to change mindset or legal reasoning to make it all compatible with the democracy. And high-ranking judges were judged from the old system. The school of judges was the same system in absolute monarchy, and the selection procedure still rely on closed mechanism, closed mechanism in the name of independence. No other institution could have a say of influence to the judiciary. The monarchy gave a lot of importance to the court. It is visible in the constitution that states that judges must make an oath of allegiance to the king before taking office. They must say, I swear an oath that I will be loyal to the monarchy and perform my duty in the name of the king with integrity. From then, the monarchy will make a speech to provide. The king will make a speech to provide both support and warning to judge. If we look in detail into those royal speech, we will see that the king speak about justice, which is to be expected. However, the way he is doing it makes judges feel like they are the part of the king. They receive their mission directly from the king. The best example is the King Bhumibol speech on 25 April 2006. This speech is the origin of Tulakan Piwat in Thailand. Concerning the training of judges, senior judges are providing training to junior judges and instill in their mind that they are part of the monarchy. For the long time, at each training, Sanya Thammasat, he is the ex-prime minister after 14 October 1973. Sanya Thammasat told new judge that in the group of civil servants, there is only one type working in the name of the monarchy. It is the judiciary. We are the only one who work in the name of the king. And Sanya Thammasat also said, if the king order me to do something, I will be happy to do it, even though I must die. Even though it means I must die. Through royal speech and legal training, judges are taught that courts are upholders of justice. The judiciary believes it is the institution bestowing justice onto people. Judges believe that the judiciary is above other institutions. Meanwhile, institutions whose members are elected are seen as corrupted, chaotic, divisive, and self-interest. Independence of the judiciary means independence from politicians, but does not mean independence from the monarchy. Both with regard to ideology and interest. Regarding ideology, judges believe they belong to the institution of the monarchy. Regarding interest, judges believe they will be honored by the monarchy in the future. often, the king has appointed the Thai Supreme Court President as privacy counselor. In time of crisis, the king has appointed high-ranking judge as prime minister. Today, out of 19 private counselors, we have 5 are judges, notably Thanin Glaivichian, Jamrat Khemajaru, Athanit Dittha Amnat, Supachai, Phung Phungam, and Chanchai Likhit Jitta. Thanin Glaivichian was appointed after the end of his premiership, and for the 4 others, they have all been former Supreme Court President. Before that, a notable who became private counsel included Sanya Thammasat University Singh, Jinda Bunyakom, Jitti Tingsapat, Sakda Mokhamakul, Santi Thakran, etc. The court used legitimacy for the conclusion. The court used legitimacy derived from principle of the rule of law and liberal democracy to conduct a mission of preservation of royalism. Ultimately, they sanctioned elected institutions and the people whom their acts that are seen as threatening to the royalist liberal democracy. This can be seen in the case of the many cases of lèse majesté and the case of we so-called judicial coup since 2006 to today. So for the conclusion, the doctrine build knowledge. The doctrine, the legal academic, build knowledge, whereby the monarchy is the central agent of the Thai liberal democracy. The royalist rule of law doctrine has led to the design of new institutions to check on the exercise of power by politicians. The court and independent organization conduct the mission to replace right and liberty as an action that are deemed a threat to the system. These institutions derive their legitimacy from discourse on rule of law democracy, but they believe in royalist democracy. They use the doctrine of rule of law democracy to suppress threat to royalist democracy. Thank you.
So I would say that we may have to move back into history and look at the beginning of the functioning of the so-called democratic system in Thailand. And I would identify 1973 as a very important milestone. I think, and if we take that, I'm very struck by Ajahn Kiyahit, one sentence, talk about Ajahn Mon. And he said, when it is impossible to withhold election. Okay, so I mean, are we looking at the Thai state as having the, most of the time, democratic system with the intervention of the military coup? Or are we talking about the other form of state being quite powerful, being dominant, which allow democracy to function intermittently? I think it's a big question. And I'm not going to answer that. I'll leave it to Ajahn Chayan.
I think these 2 presentations are self-contained in themselves. It's a very clear window to see the distortion of the legal principle in Thailand, as well as, if I may say, the absurdity of the current political situation in Thailand. I think these 2 presentations give very much a clear window to that. I would like to make 3 major points. One is to put these 2 presentations into like historical, if you like, to the wider context. The traditional elite, they use these 2 tactics. One is to appropriate, and the other is to expropriate. That is to say, if we look back since 1932, when the tide of democracy came to the shore. They appropriated it. Okay, they granted it, they agree with it, it's very good democracy, and this and that. But if it went too far, they expropriated it. Yeah? To Vietnam, as we know. Yeah? They stopped it, they put a stop to it. The period of 1933 to 1976 is a good case in point. Yeah? When the democratic forces were apparent, like democracy, like people were on the move, they liked it. Not that they didn't like, they liked it, but they appropriated it. They talk about democracy and this and that. But when the students went a bit, quote unquote, too far, they stopped it. They killed people, as we know, on the football ground, Thammasat, over 70 of them. They expropriated it. But again, this is a kind of tug of war. It's a kind of tug of war. Yeah? They pull one way and we pull the other. After Suchinda, which year Suchinda? Suchinda. 1992 is another example, and you can illustrate that. Okay, like democratic forces became strong, they appropriated, they talk about this constitutional law, they talk da. And then when it went too far, they did it again. And this can be seen not only the bigger picture of politics in Thailand, but also the weakness, like Dr. Piyabutr and Dr. Eugénie talk about. For example, the Constitutional Court. It sounds very democratic, It will prevent, it will preempt coup d'etat and this and that. But they use it. They use the Constitutional Court for their own end. The commission election is another case in point. Yeah? It sounds very good, that we may have a free and fair election. And how they appropriate the works of the commission election. Yeah, I am impressed when Dr. Piyabutr talk about Thammasat University, that they found it, to build the spirit of new spirit, democratic citizen. Look what had happened today to Thammasat University. I worked for Thammasat for 9 years. Yeah, I didn't see much of it, let alone today. But leave that aside. I want to emphasize that this is their tactics. This is their strategy. Appropriation and expropriation. This is my first point. The second point is this. You see, we see the absurdity, how absurd it is when they talk about one thing but they mean the other. We know since the coup d'etat, which year? Thaksin.
2006.
Huh?
2006.
2006. Okay, 2006 to 2016. To 2016. We see the polarization in Thai society very as never before. In fact, the division in Thai society has been apparent all along. But this division has been aggravated by other divisions, like, for example, ideological, economic, and political aim, and so on. Therefore, we are witnessing polarization and division in Thai society, and it has been intensified. As we know, I don't know whether if you witness, if you have friends in Thailand or you go back to Thailand or that, when conflict, it happens in every social unit, be it workplace, be it in family, within friend group, like group, you call it like group, they argue, they fight on these lines, like that. Yeah? My own experience is can illustrate that. Not only my own experience, I think it's experience for most people in general. So we have division regional-wise, class-wise, yeah, profession-wise, and so on and so forth. And this will continue. And this is a dangerous situation. In my view, this is a kind of my premonition, yeah, and I hope that my premonition is wrong. I wish it's wrong. I wish it's wrong. Yeah, that's what's going to happen in Thailand.
The little remark about the Thai Constitutional Court. Back to the past, one or 2 years before the coup d'etat in 2014, we can see that the role of the Constitutional Court was very active. The Constitutional Court ruled that the amendment of the Constitution was undemocratic. The Constitutional Court ruled that the unconstitutionality of the Bill 2 trillion baht loan for mega project, the ruling on the illegality to the transfer of a high service servant, Kun Thawin Pien Si, and finally the Constitutional Court dismissed Prime Minister Yingluck Shinawatra. But the army staged as a coup d'etat on 22 May 2014. From then, Tulakan Piwat stopped to play an active role. The Constitutional Court did not say that the coup d'etat was an overthrow of the administration and undemocratic seizure of power. The Constitutional Court did not say that the Prayut government, even though he implemented the same policy as Yingluck government policy, was unconstitutional. So maybe I think today we can call the Thai Constitutional Court is not the Constitutional Court. It is the coup d'etat court, the court for coup d'etat. It is not the Constitutional Court in Thailand, but for around the world, the Constitutional Court is the important institution for the create liberal democracy, for organize for create the rule of law, for support the rule of law. But in Thailand, I think is the hybrid regime is the we can import any institution for the foreign country, for the Western country, from the Western country, but we can also that we can change the law of this institution. For example, the Constitutional Court. I think it's not the Constitutional Court; it's coup d'etat court, the court for coup d'etat.
Okay, so I just first of all, I'm really happy to see that. I'm just going to use a little bit of a perfect to see that we really agree. So maybe it's because I read both of you extensively and I really like your work, so it's my opportunity to say it. So I completely agree with what you said, and I just want to show that. So first of all, about 14 October 1973, exactly. Actually, I think that the deep state was constructed in the 1960s. Because it usually in countries where it happens, the deep state is built through with the help of the USA. So if you look at Turkey, if you look at other countries, even Indonesia, we see that there is a strong military influence in those countries, building the military as a power against the communism, for instance, right? So that's I think also a legacy from the 60s in Thailand. And actually, the deep state, this is the authoritarian structure at the center of the state, and it allows exactly what you said. I quote you: "It's a type of state that allows democracy to function intermittently." Exactly. So it allows elections to take place sometimes, right? But when the government wants to challenge the deep state, for instance, interfere with military appointments or interfere with the bureaucracy or interfere with the judiciary, then the deep state is going to take over the state. So whenever there is a military dictatorship, then the deep state is the state, right? It doesn't mean the deep state is a unitary actor. Of course, it's just like a state. It's an actor that is full of contending factions and so on and so forth, right? So 1973 would be the time when we kind of stepped out of this military dictatorship. So we have this happening from 1973 to 1976. Just how you pointed out very rightly that at that time it allowed some extent of democratization to happen. And then whenever it became too threatening because of communism, basically, or socialism, then the deep state took over again. And so I think that's what happened also in 2006 and 2014, so thank you very much. And second point, appropriation, of course, this is what happened. Legal transplants all the time. Bawang Sakuwano Amon quoting foreign doctrines, foreign tools of democratization to say we're doing it for democratization, but then giving a new meaning to those terms for their own hegemonic interest. And a third point is about charisma and barami. I think it's important to talk about barami and not charisma because barami is a specific term, and I think in the case of Thailand it's really a question of barami, of how power is actually exerted informally by quoting the barami of the king, which is something you would not do in other society. So I think it's right to talk about barami.